How does the defendant, Mr. Salguero-Olivares, plead to count 1, murder, count 2, first-degree burglary, count 3, first-degree rape, and count 4, first-degree sexual offense?
Not guilty to all charges.
More than a decade after college student Faith Hedgepeth was found allegedly brutally raped and murdered in her North Carolina apartment, investigators believe they may have finally found her killer.
We all want this trial to be fair and impartial because there is a lot at stake here.
As the suspect's trial gets closer, attorneys for the prosecution and the defense are battling it out in pretrial hearings. We are taking a closer look at the background of this case and how a judge's decisions ahead of trial could impact a jury. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. In September of 2012, 19-year-old Faith Hedgepeth was entering her third year at the University of North Carolina, Chapel Hill. She was staying temporarily with a friend in a one-bedroom apartment off campus. And that is where her body was found on September 7th. On the night that she died, Faith had a packed schedule that really highlighted college life. According to the timeline that police put together, she went to an event at a sorority, Alpha Pi Omega, went to the library to study, and then returned to her apartment and got ready to go out to a local nightclub that allowed anyone 18 and up. Her roommate says that they went home at around 3 a.m. and Faith reportedly went to bed. What happened from there became a mystery that wouldn't have answers for years, or potential answers for years. According to police, her roommate, Karina Rosario, told police that after they got back to the apartment, she ended up leaving again around 4:30 a.m., that she and another friend, Marisol Rangel, came back at around 11 a.m. and found Faith. And then almost exactly 9 years to the day, there was finally a huge break in this case. Using genetic genealogy, which we've talked about before on this show, which helps connect law enforcement with potential suspects through their relatives, Chapel Hill police got a DNA match, a potential DNA match. And it was not who they may have expected. And we're going to get to that in just a moment. But I want to go back to 2012 at the beginning of the investigation, because this is what a police warrant application said about the discovery of the homicide on September 7th. Quote, when officers arrived, they were greeted by the primary tenant, Karina Lynn Rosario, who advised that she had seen the victim, Faith Hedgepeth, and that she was unresponsive. Rosario permitted officers to enter the apartment. Officers conducted an initial protective sweep and located Hedgepeth dead in a bedroom on a bed face up. Miss Hedgepeth's body was hanging off the bed over a pool of blood with her black shirt pulled up over her head. She had no clothes on from the waist down. There was blood spatter on the closet, and a used feminine product was lying beside her on the bed. And according to police, in the center of the bed was a note, seemingly written in pen on a white takeout food bag, and it said, quote, I'm not stupid, B-word, jealous. An autopsy, according to the Daily Tar Heel, found that Faith was beaten to death. You are talking serious blunt force trauma to her head. The News and Observer reports that investigators believe she was hit repeatedly with an empty Bacardi rum bottle, which reportedly had blood and tissue on it. All right, real quick before we jump into this any further, I just got to call something out. I think it is really important. The Medicare annual enrollment period is right around the corner. And if you or someone you love is on Medicare, you really should pay attention, because the truth is Medicare can be really frustrating and honestly pretty confusing. Millions of seniors are on the wrong Medicare plan and they don't even know it. That is why I'm telling you about Chapter. Chapter has unbiased, independent Medicare advisors who are salary-based. They're not paid on commission, so they're not trying to sell you something. They help you understand your options and find the plan that best fits your needs. The call is completely free. There's no pressure to enroll in anything. If you're already on the right plan, they'll tell you that. If there's a better option for your situation, they'll walk you through it step by step. Most people can review their options in under 20 minutes. And historically, seniors who have worked with Chapter, they have saved an average of more than $1,100 a year. So don't guess when it comes to your Medicare coverage. Call Chapter today at 845-493-3791. Again, that is 845-493-3791. You'll speak with a real person who can help you understand your options, and the call is completely free. WRAL News reports that police found semen on Faith. but law enforcement, they wouldn't confirm publicly if she'd been sexually assaulted. And as officers dug into Faith's life to try to understand what was going on here, there was someone who quickly shot to the top of the person of interest list, a man named Eric Takoy Jones. Now, Jones had apparently dated Faith's roommate, Karina, but they'd broken up, reportedly after there'd been some domestic violence in the relationship, or at least that was the allegation. In fact, Faith allegedly encouraged Karina to take out a restraining order against Jones. Here's what a warrant application says about how he came into focus. His name is redacted from the report, but they're talking about Jones. Quote, the Chapel Hill Police Department received a call on September 9, 2012 from a woman who was a former roommate of Hedgepeth. The former roommate stated that sometime between the months of May to July 2012, Hedgepeth told her that Jones hated her, Hedgepeth, and told her he was going to kill her, Hedgepeth, if Rosario did not get back together with him. Through preliminary investigation, affiant learned that a restraining order was issued against Jones by Rosario on July 11, 2012. The basis of the restraining order was a domestic assault to which officers with the Chapel Hill Police Department responded on July 11, 2012. In this incident, Jones kicked 2 doors in the apartment off their frame. As a part of this investigation, affiant also received several accounts of Rosario being seen with visible injuries to her body that were reportedly inflicted by Jones. Affiant learned through further investigation that Jones resented Hedgepeth because of her influence over Rosario. Several witnesses also advised that Jones considered Hedgepeth as a barrier to their relationship. After the interview was complete, Jones returned to the crime scene and walked right up to the crime scene tape. Officers had to ask him to leave because Rosario's 50B was still active against Jones and she needed to return to her apartment. Now, investigators, they also heard from another anonymous source that Jones had reportedly texted them the day before the homicide asking for forgiveness. He also allegedly updated his social media with this statement, quote, "Dear Lord, forgive me for all of my sins and the sins I may commit today. Protect me from the girls who don't deserve me and the ones who wish me dead today." Jones apparently told detectives he last saw Faith at the nightclub, but Jones's DNA, here's the kicker, not a match for the semen found at the crime scene. So investigators, they were back to square one. According to warrant application, security video from the Thrill nightclub, which we've been talking about, apparently showed Faith and Karina interacting with a few other men before leaving. So officers, they track down all these men, they request DNA samples from them, but again, continued to hit dead ends. 2016, police release a composite sketch that was created by Parabin Nanolabs. It's based on the suspect's DNA. It's called phenotyping. It reportedly indicated that the suspect was likely Latino with olive-colored skin, brown or hazel eyes, black hair. And then you go to 2021. This is when law enforcement held a news conference to announce that they had made an arrest in Faith's murder. Miguel Salguero-Olivares, the now 33-year-old, hadn't been on their radar at all. Officials reportedly obtained his DNA during a DUI investigation a few days before the announcement, and that is when they matched it, or apparently matched it, to the sample at the scene.
While we understand that nothing can fill the holes in your hearts, we hope that knowing that a suspect has been arrested and is off the street reassures you that we are one step closer to justice for Faith. Sometimes justice is swift, other times it takes longer. Today, after 9 years and a week, an arrest has been made in the murder of Faith Hedgepeth. Today's important announcement proves the power of partnership, persistence, and the potency of DNA.
Any connection between Salguero-Olivares and Faith, it's still unclear. It's still a mystery. And it has now been 5 years since that arrest, 14 years since Faith's tragic death. And this man is finally going to trial. His attorney entered a not guilty plea on his behalf to 4 charges: murder, rape, sexual offense, and burglary, all in the first degree. Jury selection supposed to start in September. But even before that, attorneys were in court this week to go over the very important pre-trial motions. These motions that will dictate what a trial will look like, right? What evidence can come in, what has to be considered. And I really want to dig into some of these requests because it puts specific parts of the investigation in the spotlight. It highlights how it can be difficult to try cold cases or cases that stretch back years. And one of the first motions that was heard this week was a request to keep the jury from seeing certain analysis reports because the prosecutor here, Angela Garcia Lamarca, told the court that different agencies involved in this investigation tried all these different lines of inquiry, some of them unconventional, to try to solve this case. But that didn't necessarily mean that those attempts to gather information would hold up under the scrutiny of the court. And in an interesting twist, defense attorney James Rainsford said they had no problem with the state's request. Take a listen.
At some point during the investigation of this case, which began in 2012, and I think it might help at this point just to provide a little context for the history of the investigation of this case. And so, Your Honor, the crime was alleged to occur September 7, 2012. Chapel Hill PD started investigating. The autopsy was completed by the Office of the Chief Medical Examiner, who did, among other things, collect evidence, forensic evidence, as part of a sexual assault kit. That kit was then analyzed by the North Carolina Crime Lab, and a suspect DNA profile was identified, was found. That suspect DNA profile was then determined to be present on other parts of the crime scene, not just inside the victim's body. Chapel Hill PD, eventually along with the help of our State Bureau of Investigation, ended up conducting dozens of DNA buccal swabs of men in the tri-state area. For the court's reference, the crime lab has more DNA analysis for this case than in the history of the crime lab. They were not able to find a match to the suspect profile that was on the victim and in the crime scene. And they continued to investigate. Not finding the DNA match, they continued to sort of circle back to some of their hunches. They were following the evidence, in one direction and in another direction. And at a point, they began doing some things that were unconventional. One of those things was to submit the 911 call that was placed by the roommate of the deceased, who is Faith Hedgepeth. She's the victim in this case, rather than the deceased. And her roommate, Karina Rosario, was the first to find it, along with their friend, Marisol Rondo. When Karina called 911, that recording escaped. And Chapel Hill PD sent that recording to someone named Mark McClish in an attempt to find anything, any kind of direction, sense of lead that might take them to the suspect whose DNA would match the crime. Unfortunately, Your Honor, Mr. McClish is really not qualified under the law in North Carolina to offer an expert opinion. If I may approach, after listening to the 911 call, he formed opinions based solely on, quote, an examination of the language used by the subject in that one 911 call. Even assuming arguendo that a scientifically reliable opinion could be formed based upon linguistic choices, Mr. McClish's analysis is not based on sufficient facts or data. He didn't know anything about the circumstances surrounding the call. He didn't know anything about the people involved. He didn't know anything about the caller's normal speech patterns or other information that would help him to reliably interpret that caller's language. It is not the product of reliable principles or methods within the meaning of Rule 2. This would be subsection number 2. Rather than employing a methodology that's been objectively tested, independently validated, subjected to meaningful peer review, or generally accepted within the scientific or professional community, he relies on a self-created interpretive framework derived just from his own law enforcement experience, which is not nothing, but it doesn't meet the threshold for expert testimony that's considered to be reliable or the product of reliable principles and methods. For all those reasons, Your Honor, the state is asking that this court issue an order excluding any reference to or substance of the 911 call.
Thank you, Madam Chair. Mr. Rainsford, you can start the defense.
Yes, Your Honor.
Yes, sir.
This is evidence that was created by the state. The defendant isn't seeking to introduce this. So I don't have any objection if the state doesn't want to try to present the knowledge on analysis and evidence. You know, as far as making a sweeping ruling that it lacks admissibility and there's something different than just saying nobody's going to try to admit it, then it's not going to be admitted. I'll leave that to the court, but the defense isn't trying to admit it.
So noted. I do think it's important that the court at least acknowledge what the state has said on the record as opposed to the court just saying no one's going to admit it. Just in case, I think it's important. You're not objecting to the state's motion to exclude, correct?
Correct, Your Honor.
Now, as part of the motions hearing, there was a special agent with the North Carolina State Bureau of Investigation who took the stand to explain some of the team's investigative choices, including having an analysis done on a written statement that Karina had given to police.
We were, as an investigative team, seeking to obtain any potential leads that we could to find the person responsible for who killed Faith. And so we were going through all of the evidence and statements that we had obtained in the case file thus far, and coming through with a fine-tooth comb to, do whatever we could to maybe follow up on leads that hadn't been followed up on.
So the analysis that you submitted to Mr. Schaefer, this is the written statement analysis from September 7, 2012 by Karina Rosario, correct?
Yes.
And you said statement, but this was the only statement that was submitted to Mr. Schaefer to be examined, correct?
Yes, I believe so.
And why was the decision to only submit this statement to Mr. Schaefer?
As best I could recall, there was a conversation amongst the investigative team about that somebody had heard of an investigator that could provide some analysis of a written statement, and it was kind of in the idea of let's try whatever we can with what we have in the case file to see what we can learn. And so that was kind of what prompted reaching out to see, what information we may be able to glean from this investigative technique that frankly was very unconventional and that none of us had ever used before.
Okay, so in this case, you've never used it before, but you made the decision to reach out to Mr. Schaefer to have him prepare a report of an analysis of Ms. Rosario's statement.
We figured we'd give it a shot and see what we got from it.
If you look at some of the things that he talks about as far as a change in a person's pronouns at a point in the story where the author abandons a thought and exchanges it for another. The original thought still exists but is being withheld, making it deceptive. I don't know respectively, where that's coming from, what that means and how he's tested that and so forth. I'm not being disparaging, but without going any further, but based on some of the examples within the motion, I respectfully do agree with the state of North Carolina that this would not meet the standard under 702. Therefore, the motion to exclude the written statement analysis is allowed. The court will note the defendant's preservation of the right to make a proffer outside of the presence of the jury at the appropriate time.
Over the years, there, of course, have been a lot of theories about what happened to Faith, who was potentially involved. Could Karina herself actually be more than an innocent bystander? That was one that came out. What about the friend that accompanied her to the apartment when Faith was reportedly first found? That was another one. There was a lot of online sleuths that have questioned their stories. And according to WRAL News, the state acknowledged that Karina had been previously investigated as a suspect. And now it seems defense attorneys for the defendant in this case, they are pointing the finger in her direction as well. According to reporting from local media outlet CBS 17, the defense gave more details about their suspicions of Karina in a court filing. Apparently, Karina had blood on a finger when she got into her friend's car after 4 a.m., which, again, this is around the time that Faith would have died, which she reportedly couldn't explain. So the blood was tested, but according to reporting from WRAL, there wasn't enough material to get a DNA match. Is that reasonable doubt? Karina also reportedly told police that the shirt that she was wearing that night had been left at her friend's house. But actually, according to the defense, that shirt was found partially underneath Faith's body. The defense also alleges that Karina used the phrase, "I'm not stupid," multiple times in police interviews. Remember, that's the phrase that was apparently written on the bag found next to Faith. And when the investigation kicked off, an officer reportedly wrote, according to CBS 17, that Karina, quote, showed absolutely no emotion. She never got upset about what she was seeing and just looked at the mattress like it was any other irrelevant object. But the state appeared to want to protect Karina if they could, asking that she not be filmed by the media during her testimony.
And so specifically with regard to, and this is an unusual case, we all know that. This is a cold case that has been, unlike most cold cases, that go cold right after the crime is committed, and then stay cold, and then there's a DNA hit, right? And then we pick up and we prosecute pretty quickly thereafter. This one is different. The crime was committed in 2012. The DNA profile on the crime scene was found. We knew that the DNA was there. The person who did this left their DNA all over the crime scene. But then, for years and years and years, we couldn't find that match. And so, law enforcement investigated. They did the best they could. It was, they followed evidence. They targeted, essentially, Karina Rosario. And I know I'm making defense counsel uncomfortable. If he needs to say something, I'm sure he'll give you a chance. But it's important to the substance of this motion, Your Honor, because it requires the court to understand more than what the court can understand without knowing all the evidence in this case. Because what the state wants to make sure we're able to do is try this case fairly and impartially. And in order to do that, the people who testify have to be able to testify. And Karina Rosario happens to be the last person who saw Faith Hedgepeth alive. And she has lived the rest of her life as the primary suspect in this case. It is still happening, despite the fact that in 2021, we found the DNA match. And she has continued to live under the scrutiny, the constant scrutiny of the public discourse around this case. Continues to be the presumed participant. For her to come and testify, which she is absolutely willing to do, is going to be unusually difficult. Because she doesn't have to just testify about something that has affected her profoundly as a person, as a human, as someone who loved Faith Hedgepeth. But she has to testify under the lights and camera and judgment of the world. And the state is genuinely concerned that when she gets on that stand, she may not be able to testify if that pressure is still glaring. And we want the jury to hear from her. The defendant should want the jury to hear from her. And so the state is asking
as to what the defendant would want. I don't want to.
Noted, I'm going to give you a chance, but noted. And I will also indicate that this argument is being made outside of the presence of a jury. A jury has not been selected. I know that these are pre-trial motions. I know that also, given the nature of this case, the concerns that both parties have, as far as making sure that both parties are able to select a jury that's fair and impartial when we get to that point in September. The objection is noted respectfully, but at this point overruled, but counsel will have the opportunity to make their argument.
Thank you, Your Honor.
Yes, sir. Yes, ma'am.
I apologize for presuming anything on the part of what the defense should want. I'm sorry I said that. What I really meant was that we all want this trial to be fair and impartial because there is a lot at stake here, including for the defendant. And, Your Honor, it's the state's argument that at the very least prohibiting the cameras and the photography during the testimony of Kareem Rosario and Marisol Rangel, who is in a similar position, although not as extreme, would put them in the best position possible to testify thoughtfully, accurately, competently, which is important to all of us.
Thank you, Madam DA.
Thank you.
Yes, sir. Mr. Rainsford.
Thank you, Your Honor.
Yes, sir.
I think what the relief the state is asking would violate my client's due process rights under the Fifth Amendment, the Sixth Amendment of the United States Constitution, his due process rights under the North Carolina Constitution. Confrontation alone, if this jury is hearing from witnesses that the state presents, and if the state chooses to call Ms. Rangel and Ms. Rosario to the stand, and all of a sudden we have to take a break, and the jury comes back in, and all of a sudden the television cameras that I don't especially like being behind me either, no offense, that's going to send a message. There is an implicit recognition at that point, at least I think, arguably enough, that these witnesses aren't, well, Ms. Rosario is in no way involved in this case. We've taken the cameras out of the courtroom. Trust her. She didn't have anything to do with anything. And that is a huge risk, not to mention, and I will just incorporate by references, the arguments that we previously made about the open courts and our objection against the state's previous request to seal the pretrial motions. And I'd rather just incorporate my reference and set 30 minutes of me espousing this. So if that's all right with Your Honor.
So noted and incorporated.
People are getting sick of hearing from me. So, but I do think that that would also impinge upon the right of the open courts. We want accurate testimony, and so I think Ms. Rosario is in a unique position, and I think hopefully this will alleviate any possible fear in that she has multiple recorded interviews, and unlike a lot of, Ms. Rangel has 2 prior recorded interviews, and so unlike a lot of witnesses that don't have the ability to go back and actually watch what they said at an earlier point in time, they do have that ability. And hopefully, by being able to review their prior discussions with law enforcement that were filmed, they will be able to get a more accurate picture of what they said to law enforcement. Because again, 15 years, that is a long time. And there is pressure when you testify. But that's going to be the case for every witness. In the motion, in paragraph, I want to make sure I cite the correct one, and I believe it was paragraph 4. The state alleges that Ms. Rosario has also endured intense and relentless media coverage vilifying her and insinuating she was somehow involved in the brutal rape and murder of her best friend. One, I would object. When a client's innocent until proved guilty, I think saying there was a brutal rape is assuming fact, not evidence, and something that we absolutely contest. More than that, it takes law enforcement out of this. I mean, the national media story that was broadcast on ABC 2020, now Chief of Police Elisa Lehue said, quote, whether or not, she is giving us all of the information that she knows and or truthful information, continues to be under investigation. And so saying that the media has vilified Ms. Rosario, I mean, that was a statement from law enforcement. That's not the media saying anything. And so I think it needs to be important that it's not the media just generating some narrative. And so I think it would also, if there were a question, Ms. Rosario, for instance, from the state, the cameras are out of here, you can relax now, or something that would seem to indicate that she was being accommodated because her testimony was, truthful, and that we don't want cameras in here and now you can tell everybody what you know, because we know what you're saying is the truth. And I think it's vouching. I think the motion itself could be viewed as a way of vouching for the credibility of the witness, who is, by law enforcement's own statements, someone they have looked at, and it's not clear to me that they're not continuing to do so. And so for all of those reasons, I think this motion should absolutely be denied, and I think it would be constitutional error, both federally and state, to allow the state's motion.
So the judge ended up rejecting the request to shield Karina from the cameras, but it is important to note that Karina does not and has never faced any charges in connection with Faith's death. Now, as far as the defendant here, Salguero-Olivares, he goes to trial in Durham County starting September 28th. If he is convicted, he is facing a life sentence. As for Faith's family, the Chapel Hill community, they are hoping this will finally mean justice for a young woman who had such a bright future.
Carolina is a different place because of Faith. Her commitment to her fellow students, our American Indian community, and her Halawa Saponi tribal roots is felt by so many today. Faith was and continues to be a Tar Heel, and we will never forget her.
According to the News and Observer, there is now a Faith Hedgepeth Memorial Scholarship Fund, helps Native American women from a North Carolina tribe earn a higher education. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can also check us out on NBC's Peacock as well. If you want to follow me, X, Instagram, my News Nation show, Jesse Weber Live, Monday through Friday, 11 p.m. Eastern. See you next time, everybody.